I'm Nancy Cavey, a national ERISA and individual disability attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this, so I've said it. But nothing prevents me from giving you an easy-to-understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. In this episode, I'm going to talk about Liberty Mutual, known as Slippery Mutual. Unfortunately, many disability insurance carriers like Liberty Mutual aren't in the business of keeping the promises they made to you when you purchased your disability insurance policy. Unfortunately, things haven't changed since Lincoln National purchased Liberty Mutual's disability insurance book of business in May of 2018. As a matter of clarification, I'm still going to use the name Liberty Mutual. Well, why? Lincoln National kept all of Liberty Mutual employees and Liberty Mutual's business model. We had hoped that the claims handling process used by Lincoln would have been used by Liberty in these cases, but unfortunately that has not happened. So I'm going to be talking about how Liberty uses the game of whack-a-mole to deny claims, Liberty's moving target games, and its failure to consider all of the disabling medical conditions, the myths that Liberty Mutual disability insurance policyholders believe about their Liberty Mutual disability insurance, and the truth, and the story of how Mr. Zaeske overcame a wrongful Liberty denial based on an alleged lack of objective basis for the restrictions and limitations assigned by his doctors. We're going to take a quick break, but when we come back, we'll get started. Stay tuned.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Ready to go? Let's talk about how Liberty uses the game of whack-a-mole to deny claims, and Liberty's moving target games and its failure to consider all disabling medical conditions. I think that one of Liberty's favorite games is whack-a-mole. You remember that game where you would whack the mole and it would pop up somewhere else on the game board? Liberty's perfected that game. Let me give you the case of Suzanne versus PNC Financial Services Group. It's a perfect example of the whack-a-mole game when it comes to Liberty's failure to consider all of the medical conditions and their moving target occupational analysis. This person was a financial analyst who participated in PNC's long-term disability plan. She stopped working because of a bipolar disorder for which she was psychiatrically hospitalized. Now, when she was discharged from the psychiatric hospital, her doctors opined that she could not work not only because of her bipolar disorder, but because of fibromyalgia. So Liberty paid her short-term disability benefits and her long-term disability benefits based on psychiatric problems only. She had told Liberty that she had been diagnosed with fibromyalgia, and her medical records did document lumbar spondylosis, degenerative cervical findings, and a disc protrusion at C5, 6, 7. And so there were at least a number of physical medical conditions that were the basis of her claim for disability benefits. So Liberty had her file reviewed by Dr. Catherine Siebel, who had difficulty reading the records she was supplied by Liberty. Unfortunately, Dr. Siebel didn't speak with the treating physicians and opined that the records did not support any psychiatric diagnosis, despite the fact that she had a psychiatric hospitalization. The treating psychiatrist wrote a report disagreeing with Dr. Siebel's findings and provided Liberty with an explanation of the findings together with updated medical records. Whacked one mole. So then Liberty decided they were going to get a second review by Dr. Ratter, who confirmed the bipolar diagnosis, but he concluded that the medical records did not contain sufficient information regarding the occurrence of the symptoms, direct observation by providers of the mental status examinations, and information to support any impairment from a bipolar disorder. Now, Ratter actually spoke with a treating psychiatrist who disagreed in writing with Ratter's conclusions and recommended that Ms. Hassan be seen by a pain specialist. So we whacked a second mole. Liberty then had a third review by Dr. Sidhu, a family medicine provider, who opined that none of her physical impairments caused any type of restrictions and limitations, nor were there any objective findings of abnormality based on exam findings or diagnostic studies. Dr. Sidhu didn't think that any of the disc pathology caused any impairment and that there were no side effects of medication. So guess what? Liberty upheld the claim denial based on the bipolar and cognitive issues. So what happened next? Well, she filed an appeal that included her updated medical records, test results, including an EMG and nerve conduction studies of her upper extremity, which revealed carpal tunnel syndrome, an MRI of her right and left shoulder, a neuropsychological report, medication change information, updated attending physician statement forms, and an audio recording of the treating psychiatrist reading his records. Okay, she whacked a third mole. Well, guess what? On appeal, Liberty had her file reviewed by Dr. Panzer, a psychiatrist, and Dr. Klein, a physical medicine and pain management provider. Panzer spoke with a neuropsychologist who opined that there was no functional or cognitive impairment. And as a result, Panzer in turn opined that there were no restrictions and limitations as a result of bipolar or cognitive issues. Klein spoke to several of the other medical providers who were treating her multiple medical conditions, and they were advised that she could perform her own occupation. Liberty obtained then an occupational analysis on the same day as the claim was denied. But that analysis failed to address the carpal tunnel syndrome's impact on her ability to perform her own occupation, which required repetitive use of her hand with handling and fingering. Now, that was pretty sneaky, wasn't it? She filed a lawsuit, and the case was decided under what's called the arbitrary and capricious standard of review. Susan argued that Liberty kept on moving the target with its occupational analysis without giving her an opportunity to respond, and failed to consider both her shoulder and her carpal tunnel issues. The court agreed. But unfortunately, the court rejected the argument that Liberty had improperly relied on the peer review providers over that of the treating physicians, and that's not uncommon. But the court, as I've said, held that Liberty acted arbitrarily and capriciously by failing to address the carpal tunnel and the shoulder issues, and failing to give Susan an opportunity to respond. Liberty lost its game of whack-a-mole. Hopefully, you can see how disability carriers like Liberty Mutual keep on changing what they want, how they want it, who they want it from, and the impact of the information that they get. They just keep on changing the target. In the next segment, I'm going to talk about some myth busting involving Liberty claims, so stay tuned.